For judgment, item number 1, WPC 221354 2017.
Accordingly, it is directed that the management shall pay a sum of rupees 5 lakh to the workman opposite party number 1 as lump sum compensation in lieu of reinstatement in service, along with 50% back wages within a period of 2 months hence. If petition is disposed of accordingly in the facts and circumstances of the case, there shall be no order as to cost.
I have a case.
For judgment, please.
Give the memos.
For judgment, item number 1, WA 119 of 2025 and batch of matters.
Just current appeal is allowed. So also the petition as a consequence thereof, and all pending interlocutory applications shall stand disposed of, but in the circumstances there shall be no order as requested.
Second one.
In terms of method.
Item number 2, WA 432 of 2025.
With the opposite of the response and directions, this civil appeal stands disposed of along with the pending interlocutory applications, but in the circumstances there shall be no order as to cost.
Press admission, item number 3.
Senior counsel will argue on this case on the after. What do you want?
You want adjournment?
Yes, sir.
Yes. As Lieutenant Senior Counsel is unavailable, the matter will be said. Adjournment is sought for. Relevant. Appointed.
Yes, ma'am.
Yes, ma'am. 2 weeks accommodation is sought for. Allowed.
10th July.
Thank you.
Item number 4.
Who is here?
Umesh Chandra Jain.
In this matter, the state has already filed the counter-affidavit on e-filing mode, but there is noting that it is not.
It has not come
It has not.
on board. It is stated by additional government advocate.
But
First record none appears on behalf of the petitioner. And then
It is stated that the additional government advocate that counter-affidavit has already been filed in the registry. The registry may locate the same and place it on record on the next date of listing. List this matter on
3rd July. Item number 5.
That's 6/5/24, my lord. Not yet complied.
what was that order?
Order, my lord, let's turn to page 15 to concluding part.
all consequential benefits.
Shall be entitled to the benefits arising out of the amendment rules.
All the benefits arising out of amended Rule 15.
Yes.
Yes. Have you, this is the first time?
First time.
Serve a notice. Returnable after 4 weeks.
Shall we say that
First is a notice.
Huh.
Then they will get an opportunity. What the rule?
no, I'll not say that. The status of consideration, because there is no time limit fixed.
Okay. So let them come. That's why.
But take instruction from the notice.
Notice has to be, this is the first motion, so it has to be given.
Notice to the opposite party contempt. That is the
Is there
additional.
any rule for contempt framed by us?
No,
Contempt rules
no.
by the High Court?
First time, what
No, no, no. We have the statutory rule.
the last one was contempt. Chapter 18.
Is it separate rules or?
Separate rules, separate. Sir, छोटा बही बता. अच्छा नहीं है. One chapter.
Chapter?
Chapter. There is no separate rules. Only chapter is added. 3-4 rules. It's not actually proper.
Okay. No, we have a separate rules. That's why I'm saying.
No. We don't have separate rules. Contempt rules.
We don't have a separate contempt rules.
Page 82.
Huh?
Page 82.
In this book.
No.
Separate.
Returnable debt is the.
The extra copy or extra copy of.
Yes, I will give it to you.
That's.
Yes.
Item number 6.
Returnable debt may be.
Yes.
This is.
My lord,
Item number 6, I'm appearing for document. I have entered appearance for opening number 1 and the entry reference to the portion number 2. I will use of that for opening purposes. I will not receive the I use the forum which I will grant. I'll the counter.
And for the petition, the MCL of the party floated ended.
the refund of the honest money.
Honest money, as well as one clause is there, in the event of failure on the side of the MCL, they are supposed to give me the compensation. I am not here on the quantum of compensation. What they did, as per Annexure 11, Annexure 10, they denied my claim by saying that we are not entitled to get the compensation in view of the fact that there is an inseparable clause, which speaks, my lord, there was no environment clearance. My humble submission for lordship, before floating the tender, you could have intimated, you could have obtained that environment clearance. Thereafter, the tender could have been floated, for which I could not operate the coal mines for 41 days. Thereafter, I started for 4 days. I was supposed to take from the 30 metric ton, but I could able to only manage 7,500 metric ton, for which I filed a repentant as per their own clauses, their tender clause. I filed application before this.
So it really originates from from a contract, and if the contract is silent, then in that event, one cannot import unilaterally something
Yes. That is
into
right.
it. That's your case. That
Yes, my
if it was not in there in the incorporated in the contract, then you cannot insist.
No, well, my humble submission.
There is a clause, inseparable clause. He says that is to be utilized in a particular manner.
Yes.
We are saying it is to be utilized in a particular
That's an interpretation.
interpretation.
Yes, ma'am.
Interpretation.
How much time?
3 weeks,
You
Lord.
take time, 2 weeks time,
3 weeks time, Lord. My friend.
2 weeks is enough.
Fine. Rakesh.
That's for MCA.
Yes.
All the.
Manan Kundu.
Third July. 3rd July. Item number 7.
It is related to the construction of a bypass road, reversing the original plan, creating two blind curves in between. And in matter, the lords were directed twice to take instruction of what can be done better.
We have already received instruction, Miller. Last occasion on 29 for 2025, an order was passed that to obtain instruction regarding
Yes, I have seen that.
annexure 4 Miller. The instruction we have received.
8-5, the order was passed, my instruction.
So what instruction is that, Miller? Tahsildar Begunia has informed that the committee has been constituted and the members of the committee are the superintendent engineer, Tahsildar and other officers. And they have scheduled a visit to the spot this week, Miller, and they are going to sort it out.
Because the annex of 4 is there
For the state subject on instruction. Received from a responsible officer.
Tahsildar Begunia.
That and the issue raised in the instant public interest litigation has been addressed, and a committee is constituted to oversee the construction of a road. So it is further submitted that the committee is contemplating to make a physical inspection of the site in course of this week or a coming week.
This week.
In the course of this week. And the decision shall be taken thereafter. Whether the Grovans whether the issue raised by the minister is acceptable or not. Either straight for an accommodation. It is the matter of the 2 weeks. Give a report for this.
Item number 8.
Mr. Pradhan is out of station, and I have no hold stand. Mr. Pradhan is out of station.
Remain out of station for 4 weeks.
Medical ground.
In this matter, my lord, we have received instructions. We need to file a counter-affidavit.
For oh, this was a water reservoir.
Yes.
And maintenance of the level of the water. I think the last occasion there was another matter where they said that they have taken the entire stock of the things and then say that they have increased the level
This is
and they maintain it. I think that was the matter.
This is the matter.
There was an order.
State government was supposed to take instruction.
Oh, relevant documents you were directed to
Yes.
submit. Then
We
what?
have got it, we'll file with the affidavit.
The council for the state submits that pursuant to the order dated 24/4/2025, the relevant documents have been collated and may be brought to may be brought on record by way of an affidavit. Let the affidavit be filed within 2 weeks from the. This is the matter. There are 3 weeks.
Email us again, my lord.
You are appealing from your number.
Yes, madam.
You file in response.
No, madam. If the state government would destroy.
Chandan Man. Yes. See.
Item number 9.
Financial irregularities of what?
You also kindly see the last order passed by your.
Where is Mr. Srimant?
Special Counsel for Vigilance.
Vigilance, senior standing counsel.
Senior Standing Counsel for the Vigilance Department. You was directed to take an instruction. What?
I will inform you.
Firstly,
It will be passed over to the file.
Let it pass over.
Item number 10.
Is not challenging such opposite for not executing the lease agreement for running of store going. On the last occasion also, it's not even put a direct like instruction with regard to the presentation which is pending.
Lordship, we given a week's time, your lordship, I'll seek instructions. We've already intimated them, your lordship, we'd like to receive some instructions, your lordship.
this was.
You may be pardoned, your lordship, but ensuing vacations was there and this was another bench.
In the government department.
We know, your lordship, but we as law officers have not been able to follow it, your lordship. It comes from another bench also, your lordship, the matter. 1 week's time.
Sir, what duty I think better.
We have written your lordship.
Move forward. Whether they do or not do.
No, we have already written a letter, your lordship. We will contact you, 1 week's time, your lordship. Next week and
Para 4.
next week, your lordship. 1 week time. I agree, your lordship. We have already intimated them. We've already issued letters. But lordship, as last chance next week, your lordship.
Yes.
Positive will.
1 week of the prayers.
Item 11.
Pardon, my lord. I am on VC, my lord. My lord, on the last occasion, on 25/4/2025, government had sought adjournment for release of pending bills, my lord. They have approved the bills, but till that.
Your lordship, we have received instructions
As your Lordship pleases. As your Lordship. As your Lordship pleases. Obligers.
Item 12.
And the defense of the petitioner was that he became the
L1,
L1.
so
L1.
the work order should be allotted
Yes, my lord. In the meantime, work order is issued.
already.
Yes.
So not interested. Permitted to withdraw or dismissal by infractious. So it is an infractious matter. The petition was taken out by the petitioner, alleging the inaction on the part of the parties in not issuing the work order, despite the petitioner having adjusted the lowest bidder in the tender call notice dated 27/11/2024. When the matter was admitted, the direction was passed upon the opposite parties to take necessary steps and also to take a decision in this regard. It is uniformly submitted by the councils appearing for the respective parties that subsequent thereto, the work order has already been issued in favor of the petitioner, and therefore the grievance raised in the writ petition is already redressed. In view of the above fact, the instant writ petition has become infractious and accordingly dismissed.
Item number 13.
Your Lordship, I have a draft order dated 8/5/2025. The last level. State was directed to file an affidavit.
Yes, Your Lordship,
Where is the affidavit, madam?
pardon, Your Lordship. Tahsildar has come, we had a discussion, Your Lordship. There were some documents wanting. We have a very good case, Your Lordship. There were some documents wanting, Your Lordship.
According to him or according to you?
After the discussion and after seeing that the lacunas, what were the lacunas as alleged by the petitioners, Your Lordship, he has documents to show that there were no lacunas, Your Lordship. And Your Lordship, he is Tahsildar Puri. So, Your Lordship, the Rath Yatra is on 27th. He's been constrained to come to that again sign the affidavit, Your Lordship. It can be posted to 14th of July. And before that, if I can get a chance to file the affidavit, I will intimate the court, Your Lordship, and it will be listed. Matter can be listed. I will also intimate the petitioner.
Wash pieces.
I understand that.
Puri. Your Lordship.
And the construction will be made in the meantime.
No, Your Lordship, they,
I know the difficulty.
You were also this side.
Yes, I know.
Same.
Yes, sir.
because he's of Puri, Your Lordship, I am seeking this review. If he files the affidavit, I'll intimate the court.
3 weeks.
Extension. Because there was already a.
3 weeks. For
Filing that.
filing the affidavit to compare with order dated 8/5/2024.
Obliged.
July 2nd.
Time to file affidavit is extended by 3 weeks from it. And is the matter on 14th.
14 July. 14
Yes,
July.
Copy of the counter is not on going on.
Yes, Your Lordship. I
That I'll be able to file my
That's
test.
why I
Yes.
always keep a matter 1 week thereafter, so that
Correct.
in the meantime, you get an opportunity to go
Yes,
through
yes,
that.
yes.
oblige, Your Lordship.
Item number 14.
Item number 14, Lord, is a matter similar to that matter whether Tahsildar under Annex 5 can issue notice post amendment.
So,
Your Lordship,
mining officer.
your Lordship has kept a similar matter to tomorrow.
I'll
Let
seek
it come
instruction.
Along with
Yes, madam, you have to take a call.
Yes, Your Lordship.
You are a responsible officer of the government. So you should apprise him that once the government has taken a conscious decision, amended the rule, then how can you assume the power?
I'll do.
And if he does it, something is to be done,
Yes, Your Lordship.
because that really augments the state of litigation to come to the court.
I will seek instructions, Your Lordship, if at all he's been authorized by any government.
Can't be, because there is
Can't
no
be.
question of any authorization.
Yes,
No
yes.
authorization.
If a mining officer is absent, I do not know, Your Lordship.
Doesn't permit you.
Yes, Your Lordship. That I
Delegation
agree.
of power is not there.
Yes, Your Lordship, I agree.
Even groups of business won't allow you
Yes.
to delegate other than the department which is in session of such a matter now by virtue of this amendment.
Yes, Your Lordship.
Tomorrow,
Item number 15.
what is that matter? So
Sorry,
that it will
sorry.
be just.
16182. The earlier matter was 16182 of 2020.
Don't tag it, but immediately there in serial number. With, don't tag it,
Back.
but separately, just immediately there.
Item 15.
By legal option. So last occasion, person instructed to, directed to take instruction to the state.
Where is Mr. Das?
1 week time, Your Lordship, the instructions is awaited. This is relating to a fake certificate and joining on the basis of a fake certificate. Employment, Your Lordship, that's it. 2 weeks time, Your Lordship, 2 weeks. As a last time, we'll get the instruction.
Yes.
One week.
2 weeks.
3rd July.
Obliged.
Item 16.
Yes, what you have done, have you removed the encroachers?
Whose property has been enforced by law?
It's come for the first
They
time.
are just reminding you that your land is being encroached and you are not protecting your own land.
I'll seek instructions, Your Lordship.
What instruction?
This has come for the first time, Your Lordship, I have instructions.
Is on the player to receive instruction? 2 weeks.
Well,
Because it is inconvenient for the students, those who
Oh,
are.
I understand, sir. I've seen
My
that.
lord.
item 17.
Obliged.
So now immediately after receiving the briefs, are you not uploading it in your LLS?
It's being uploaded, Your Lordship, but in that,
Wait,
yes.
beforehand, before we take up the matter,
No, Your Lordship.
or after we take up.
Sometimes, Your Lordship, sometimes a brief, whenever the brief is filed, it is generally uploaded. If there is some time gap there. Otherwise, we ensure that it is uploaded by the time we send a letters, Your Lordship.
Try to get the instructions before we list it. So
Because there we had made a rule relating to this writ, that no writ petition would be listed unless the copy thereof is served upon the government officials at least 48 working hours.
Lordship, what is happening
So
inside?
that the object was that this is the sufficient time to get an instruction.
What is happening, your lordship, is that when it is being uploaded in the LMS, that is what we had a discussion. It's not on a department wise, your lordship. It is on general term, it is uploaded. So when we inform through our letters instruction that you can get this on the LMS site, we have uploaded it with the case numbers and
Don't they have an access to this particular?
they have, your lordship, but but it is not uploaded department wise, your lordship. On a vote.
The system has to be generated because the moment something is uploaded and relating to a particular department or a particular.
That is not indicated,
Yes,
your
sir.
lordship. That
It
is.
is always there in the petition, then it should be immediately routed to a
Yes,
designated
yes, your
body.
lordship. That is what we had a discussion with the advocate general.
Every department must have a particular unique password
Yes,
number.
your lordship. That
They go and just make it so that they can have all the matters which relates to them. That would be shown.
we had a discussion, your lordship. It has to be upgraded to that.
This is the department gets that.
Yes, but that is not there. in-
Nodal officer, whether you have nodal officer.
We have, your lordship.
Each department or not.
Yes, your lordship, but what is happening is that,
Only one day, madam.
but the LMS site doesn't have.
The
a
computer
particular,
software engineer, I believe, is already employed in the government
Yes, your lordship.
department.
That.
NIC is also there.
Yes, your lordship.
Just
That,
instruct them, it's a matter of one day only.
that
You
we
can
have
create that.
spoken to the advocate general, your lordship, for it to be improvised, your lordship.
Item number 17.
Yes, it is lordship. Where in the PIL is matter for challenging the
Where is the Hanuman temple?
my lord, it is in Patrapur village. ma'am. I'm challenging the illegal action of the opposite party.
What is this illegal encroachment?
Yes, my lord,
Village
few
road.
of- some of the villagers has constructed, my lord, permanent as well as temporary fencing over the government plot. And they have captured the road, my lord.
What is this? Nobody can have an access to the road. If the road is enclosed, the access to the road is impeded.
Not only in the temple, my
How
lord.
can they offer the
over-
prayer and a puja? Think about it.
I'll seek instructions, your lordship, 2 weeks.
Yes. Weeks.
Lordship, may dispose of the matter, my lord, with the direction to the opposite party now.
They must take a list.
All right.
That is far
Because
because they have to make a physical inspection.
already, my lord,
It is far.
What has happened, my lord?
There is an encroachment, then definitely they have to initiate a proceeding.
yes, ma'am.
Initiate a proceeding. Yes.
My lord, there is a report from the RI, the opposite party. ma'am.
They have to verify it.
All right.
That's not sacrosanct in that sense. Yes.
Item 18.
Whereas the president, petitioner is a member and the president of the primary cooperative society, Bilaspur. Government has sanctioned for infrastructure of the society. The sum of rupees 30 lakhs, my lord. And the work has to be executed by the block. Now the block, that is the guideline that the work should be. That is, my lord, annexed 4 is the guideline that says that works costing more than 10 lakh shall be taken up through transparent and competitive tender process following due procedure laid down in the OPWD code. The petitioner is the president, and when he inquired about the matter, he found that in the proposed site, construction is going on without any tender. And he also asked for under the RTI Act, that is under Annexure 8, there says that has been inferred that for the construction of infrastructure of Bilaspur PSCs have not been issued any work order, no file is open.
So then how the construction is going on?
Well,
If no work order is issued, then how the construction? I've got a photographs annexed to
yes,
this.
ma'am.
Where it is?
Photograph is in the works.
That is my lord, annex of three, page 14.
Sure.
Page 14.
Yes, that shows that some construction activities are going on.
9/4/2025.
The instructions will not damage building. The instructions.
Nothing needed to stop it.
Inform them to stop your
No
lordship.
work order, nothing has been done, so how can this construction?
I will inform them to stop your lordship on the construction and seek instructions within 2 weeks. Your lordship.
Item number 19.
But the local universities filed this, they are opposing the was able on shop. But the first officer might kindly see page 14. Page 14, it was rejected because there is a violation of 26 of Orissa excise rule.
What?
A clear violation of 26 of excise rule. Kindly page 14, last para. Preliminary inquiry of the application was conducted by the Inspector of Excise, so and so. Inquiry report reveals the reports, and so and so. You'll also kindly see next page. Next page, page 15. In view of the institutions such as one public school at a distance 339 meters, government elementary teacher education institution at distance 200 meters, at a distance 250 meters, I am not inclined to recommend. So that clear violation 26 of excise rule. There are my lord. Next government has
500 meters.
yes. That yes.
Distance no.
Yes. Says that is has rejected. The
No,
proposal
not rejected. He recommended that it should not be given.
next my lord, the government has recommended to reassess again. You have reassess and to open the bill.
So now,
I have
the
filed
recommendation
repeats,
of the excise commissioner is binding on the government,
because he is the recommending authority.
correct? So that means the once the recommendation is made, it is sacrosanct, untouchable. Nobody can touch it.
Yes,
That's
sir.
it a law.
No, that is true. And your kind to next page, my lord.
So there is a reason. If the reason is assigned, then what can be done?
It has been directed that proposal need to be reassessed and see to reassess and resubmit the proposal. I have filed a repetition report annex 3. There is, I think, no.
What is that? Rule 26.
Yes, there are within 500 meters. There must
Right.
That
Is
is
there any action
provision
provided?
for relaxation
no delay.
at the behest of the government. Where is the rule?
26.
Show what the rule. Excise rule.
That is on there. That one clause is there, provided that restriction on minimum distance as mentioned on the clauses B and C. B says by the urban area within at least 300 meters in case of rural
And
area.
500 radius.
Yes,
Educational institution.
yes, that is it.
So
So there's less some relaxation on special circumstances.
yes,
B and C.
so that power is there. That's why I'm asking.
B and C. Therefore, I have filed a representation. The local people have filed a representation for the excel that may be considered.
But that is not like a lands.
That may be considered. I have
Whether
filed-
it is a special circumstances or ordinary circumstances is within the wisdom of the government. Is they think
Because I
about
have
it.
filed the arrest of fees, my reference that may be considered.
The special circumstances that the government has taken note of everything.
Lordship in annex 2, page 16.
Objection to institution. Towards grant of license are presented. However, they are not
Directly visible.
Basically, coming to offers.
What is the difficulty? They have cited a reason for that, and they took note
No,
of
that- every intervention I have
withdrawn.
Yes,
Now,
intervention.
it's a function mechanism of the government. You can impinge only on the ground it violates any of the constitutional provisions, any of the statutory provisions, or on the ground of reasonability, test of reasonability. How can you do it?
It's minor, I have stated minor in is page 17,
Yeah.
that's second para. Because of this, I am also that the other illicit recruits are been shown.
That power to relax is already there.
That is
It's
that.
provided. So you can't say
Yes.
that they cannot invoke the proviso.
I-
If they have a statutory powers, if they exercise the statutory power, how can you say that you should not?
My prayer before Lordship, my answer 3, my kindly consider so. My
Or at
request,
the PIL,
yes, my,
or PIL,
yes.
is it maintainable?
Because the local people, sir, because there within that local, that one,
PIL, or it's a class action.
the local people, sir, because
Then whatever you make, there will be
That-
many
that
people
is-
supporting or opposing, then we are granting only make up
only
applications.
my representation, this,
Let us see.
only representation. Only my. But that only annexed to explain according to law.
After this order is passed,
Yes.
that representation is, perfect.
Yeah, my representation is my role.
Government has taken decision in September, in April,
21/4/25.
17/4.
25.
21/4/25. I have filed the petition.
So your representation is on
21/4/25.
after that.
Yes. Well, that's considered in accordance law.
Objections against the last. The rank of lessons by research, government and third department. But my because this is a very good 25. That the plan is approved. Some of the areas. These raised. Objections never go of. The one person JJ. 21/4. Address. The says. As of
Item 20.
Thank you, Lordship. Once you the case, yes, sir. There is again an encroachment of the government. My lord, I only served copy on me. I am acting for adjudication municipality, Alice municipality, office part number 7. Only due to the pendency of two writ application, the law say 6156/2025, 7347/2025. The only the eviction cannot, it is not possible to evict. Single month. It may be listed. Yes, my lord. It may be listed before lordship tomorrow. It will be because since 2019, the municipality is unable to, that is the expand the road. It is only the 5 kilometers road. Already tender has been done. And 4.5 kilometers has been completed. But due to the encroachment of the, that is the screens that some. These encroachers have approached the court. They have approached the court. Your lordship, the matter is pending. Your lordship, only they have, due to the pendency of this read petition, only your lordship reached. Interim order passed there? Yes, your lordship reached this matter. My lord, here. Put on records. Yes. Put on record. 6156. If there is already an interim order passed by your court, how can we direct that defy the interim order? Proceed. How can we? All the cases. He has already disclosed the numbers. If you are so still having a grimace, you can take a step. Season is entering, my lord, going on. Rainy season already started, my lord. Are you not understanding, sir? Had it been a very open and shut case, what you say is correct. But what he's saying is that yes, 4.5 kilometers have already been constructed. It's a half kilometer that could not be constructed because there are encroachment. You have also admitted there is an encroachment. Yes, ma'am. He says this encroachers have already approached the court by filing a writ petition, and the interim order of means protecting their position is passed. How can they act contrary to the order of the court? Then he will be liable for a contempt. All the cases together. But that is before the single bench. How can it be listed together? You have jumped the forum and you have come before the division bench. Rather, they have followed the path and went to the single bench. 4 kilometers already completed. Then it is better. This half kilometer will be completed. Advise us. You are a lawyer. You know the law. Advise us. Can we pass an order? Put yourself into our position. Can you? There is an interim order operating against them. Can the court pass? May I suggest something, madam? May I pay? Because of this, my lord, your lordship, because of government road, the encroach and the rescission. But the difficulty is the matter is before the single bench. But this may be listed before lordship. Only along with this. Only in an exceptional circumstances along with this in administrative side can withdraw. But not, this is not such. Now, we have filed counter everything. Only your lordship see whether the necessity urgency is there. You go and mention the matter before the single bench. Citing an urgency that this is what is, the road is absolutely incomplete. Cite the matter, whatever. Division bench is ample power matter. That's mostly. Lordship on the list this along with this. It says, there is a this matter may be discussed here. Reference only here only for a moment your lordship peruse the record and you will receive the pass. 615. I have already given the number. List this matter.
Just the election orders. Certain petitions have approached this court. In current PC number 6156 of 2025 and WC number 7447 of 2024. Yes, the orders were passed by the single judge Which distance the also transported to 800 PTE. Six. All this should be writing. This is so many. Also, appeals from other appeal parties. And also. Then you can counter. This is not.
21st July. 21st July. 28th. Madam. Item note 21.
Notification dated 13/5.
Page 23.
This is a rejection on the ground of a technical at the technical bit stage.
The single tender.
It's a single thing.
Single tender. But interestingly, I would have students for worship, but for the fact that the tender is a composite tender. Both the technical and the financial parts are together. They opened the financial bid of all the tenderers.
Not the technical.
No, they opened the technical and the financial bid together.
Okay.
So the purpose of single bidder, rejection of single bidder is to avoid the non-competitiveness. There should be competitiveness as far as the price bid is concerned. Now the price bid has been opened, I found to be competitive. I found to be the lowest and I'm the competitive bid. And that has also been published by them. If your lordship looks at page 18. The table is there. Final result publication of tender number 3.
Annexure 4.
So this is annexure 2.
Yes.
Serial number 12. The heading is final result.
Construction of an RPLF building with a market complex as Megdega GPL level.
Yes.
Yes.
This is you are
Serial number 12.
serial number 12. I'm looking. You are Pancha Barla.
Yes. Pancha Barla. ST. I'm ST. All the price bid has been opened.
Was there any exercise of matching the price or something?
But sir, after this was published, or with due respect, Mark, after this was published, there was no reason to publish another final list.
No. There is.
Another final list has been published.
Yes. But that is on consideration of representation, that is annexure
The
3
representation
at page 20 by third person.
construction of the building. Now, rainy season is coming. Therefore, he applies a kindly allot. If I am the L1, kindly allot. And their result is that they say you are the single bidder. So I am not the single. On that ground, cannot be rejected in this case.
No.
But I can understand technical bill, all are rejected. I stood on the technical bid, my bid has to be rejected.
No, let me understand. the objection was raised by one Rajkishore Bhattacharya.
Yes.
Yes.
So he raised the objection with regard to the construction of a model EWC at Ampunipara, Sanpatapalli.
So this is regarding construction of GPLA building.
No, he is referring to page 20. That is the letter dated third of
Yes, yes,
May.
yes, I'm referring.
If you please come to it, look at the subject matter.
Page 20, the Rajkishore Bhattacharya.
Subject matter.
Yes,
Consider the tender cost. I do not know. Tender.
AWC.
Construction of model AWC of at what? Ampunipara or something, and then
Right.
now you have participated
In
in
serial number
respect of
12.
another.
Yes,
That is what I really wanted to
that exactly.
invite your attention.
That exactly.
That's all.
If it is in relation to another
one.
then how can you launch upon him?
Here also, hear me 1 minute now.
Bhattacharya's,
Thereafter, the
oh, this was on a single bidder.
Yes.
The cancellation was that you being a single bidder.
Yes.
Sir, exactly. I just want to emphasize that I was not the single bidder.
No, there were three bidders.
Yes.
There were three.
The bids for the other two,
Yes.
they were cancelled as not in conformity with the conditions enshrined in the
Correct.
tender.
Right.
So you become a single bidder.
Sir, that is, I accept it, madam. But my respectful submission will be, but single bidders are rejected before the financial bid is opened. The reason for rejection of single bid is
As
that
a
the law is settled on that.
ultimately, suppose the technical bid was opened first
Yes.
and then rejected.
My case would have been rejected.
Yes.
Rejected.
But here what has happened?
KU stands in the same
Sir,
footage.
So here what has happened? The financial bid has been opened.
The same business registered.
Please, Mr. Vishwa, please consider this aspect. It's a composite tender,
Yes.
which includes both the technical bid as well as the financial
Financial
bid.
bid.
Now, normal rule is the procedure which is adopted is that they open the technical bid first. Find out the suitability of a bidder, whether he fulfill all the conditions and the criteria which are required, and then go for a financial bid.
Correct.
The reason is obvious. We understand.
On that basis, law has been settled. 2016 Supreme Court and number of decisions are there.
So that is what is the reason is the objective is very, very pious.
Yes.
The object is that if they take on a technical ground, if it is rejected, then at least the financial bid should not be open because the others will not be able to know that
No,
if we are quoted.
I about
It
it.
is what has to be kept secret. But suppose if it is done, the financial bid, it's a mere irregularity. But
No, with due respect,
can it
here what has happened?
can it confer any right in you to be awarded a
So
contract?
right, exactly what I am trying to emphasize for Simon, but I may be wrong, but let me.
No. We are all
Yes.
students.
What I want to bring your lordship notice is the purpose of opening financial bid is to find out competitiveness.
Absolutely.
Now the financial bid has been opened. Once and it has been opened, others are found to be lower than me. So my bid has been accepted as L1, keeping in view the financial bid. Then they consider that other are not technically correct. Also technical bid is rejected. But since the financial bid has been opened,
So the difficulty because they have to open a financial bid and they have to disclose
yes,
that how much price has been quoted by each of the bidder
correct,
and who appears to be L1,
L1.
L2 and L3.
Right.
But later on, if they found that there is some kind of a, say the technical glitch or there is
But there is a catch, my brother.
some kind of a infirmities is found in the technical document or a tender document.
All those questions considered, but if you're asking the OPW code.
Does it create a right into you? That is what is
Right,
troubles me.
so once the financial bid has been opened, now a fresh tender has been issued. Now,
Now the price will vary. I know, I understand. That is what. No, that creates a problem. They have done a wrong.
and that is the
They
issue.
should not have done that. Now everybody come to know that what are the prices
Yes.
quoted.
I understood.
Now the next tender for the same. Just look at it. You will be a beneficiary. No doubt.
But sir, technically that's
And it will avoid a cartel also. Don't.
No, that is the point actually I want to emphasize for us. The purpose is to find out the competitiveness.
When you have created a mess.
Only 1 minute, I'm saying. Whatever my land senior said, I can't have any dispute about the factual points. After your lordship saw annexure 3 filed by that Bhattacharya, now you are also kindly for a moment see page 23.
No, we are not concerned.
While considering that representative, for a moment only, my lord, 2 lines I will place from that document annexure 5 at page 23. First paragraph, it is about Bhattacharya's representation. Second paragraph. As per above petition, the committee re-verified all the documents of all tender process and found that following 4 number of projects are defective, and irregularities are mentioned below. That is how now the second document came, which reflects that is available at
The difficulty is that the objection was in relation to a particular site.
I understood. I understood.
Was it within your competence after you publish the final list to review, revisit
That
the
has been,
entire thing? Can you do it?
that has been done with this document.
Can it be? And that too, taking a shelter under the objection which is raised, not in relation to a particular site, but in relation to, you could have restricted it to Ankuni Pada.
Yes, I understand.
And then decided.
I understand.
No difficulty.
Because
How can you transgress your boundaries and then go to Megadega? You are in a Megadega.
But fact remains, my lord, that is also single bidder.
But the difficulty is,
Within your knowledge prior to financial bid being open.
why you opened the financial bid?
Those 2 reasons.
Why you opened?
And
You
there
should
it
not
is.
have.
I have seen that document, L1, the
Correct.
petition has been reflected there, L1.
You should not have opened.
Yes, yes.
So law says also they should not open. That
No,
OPW court says.
that also you should not. On a technical bid, if somebody is disqualified, leave it there. And then you find that it's a single bid. You could have said it's a single bid, I am not doing this.
That is
The
correct.
law is clear, the single bid
29.
cannot march over.
29.
That cannot be a single bid.
29. Well, if you also look at volume 2 of the report, that is appendix 9,
Yes.
amendment 2015. I have also filed that document with the, if you also look at annexure 6. Well, annexure 6 is the appendix is very yes, yes. Annexure 6, 1/1/2015, after amendment. The single tender received in the first call shall be cancelled without opening the bid. If you're only single bidder, then 29 says, when a response to a notice calling the tender only a single bidder is received, tender is received, in the first time, tender shall be cancelled without opening the bid. As you also rightly indicated.
When you open the technical bid, you knew
Yes.
the reasons.
Yes, madam.
So there are two situations that comes. That after the tender is floated, it is only one
Then
who has filed, who has offered. So it is a case of a single bid, nothing to be opened,
Right,
and it should be scrapped immediately and changed.
right.
But there may be another situation which has arisen.
Clause 25.
There are 7 bidders. You can't at a initial stage say that is a single bid. It is a multiple bid.
Multiple.
But at the time of considering or scrutiny of the document, you find that 6 of the bids are
Others are technical.
defective, faulty. Then you become a single bidder.
Right.
So they could not have gone to the
Right.
financial bid stage. I think
That
that gross
could-
illegality has been
that-
committed. We can definitely, we can admonish them, but it does not create any input.
Sir, at best, they could have
We
done.
can admonish them, but we cannot confer any right in you.
So
Can
now,
it be?
I leave it to your worship, but that's the only point I want to convey. Was the
No, you are
price,
correct. That
price bid is
not
open.
have. You should not have,
the price bid is open now, I am nowhere actually.
but still. It was absolutely a fault, your blunder. Not a fault, it's a blunder, I'm sure.
Contrary to their only on law itself.
What? My brother wants to inject a dairy filing injection in you, just why not telling me?
Since you have re-verified, now you re-verify. That option should be with you. And restricted to that objection only.
They're better than you.
Yes.
No, if I get it, they will not be prejudiced. I'm an experienced person, I have been qualified.
Competitiveness.
The competitiveness they have opened. So that is exact point I want to say.
They applied for 4
There
years,
were
got
certain,
No, sir.
there were certain other bidders, they have quoted less. But because of the technical, whatever,
But their
before,
price bid has been opened also. Their price bid has been
they
opened.
should not have. That is what I am saying. You are absolutely correct. They should not have.
Yes.
But again, suppose if such blunder is committed, does it automatically create a right in you?
Sir, I don't claim automatic right, no.
That
What I
is what is
say,
coming up.
Now,
You
because
know,
of
you
the-
have been put to a predicament.
predicament.
Lot of predicaments will come in your way in the next round
Yes,
of.
that is what, when they,
But,
My serious client applied for 4, got 2.
no,
so because he is competent.
Then yes, I don't think it's good though.
Competent.
Good though.
what to give him some best means of life. Ultimately, the situation will be the same.
Same.
Reconsider the single mistake. Then the law is that the single bidder no.
So, and sir, I have confused that. I have submitted for what she said.
I have seen in many of the tenders who are very, I would say critical and strict in rejecting the tender. Only thing is the PAN card is not attested. It's a curable one
Yes, curable defect.
and rejection. Too technical. I say
Essential
hypothetical.
is,
I'm thinking of writing a letter to the highest authority to see to all these things.
So
Unnecessary.
these are the things,
Yes.
these are very menial, I would say.
Curable.
which are- And these are the ministerial error actually. This is nothing which, if they did not submit the PAN card, I can understand that is very
Yes.
important. But
Online
not
online
attested, so
software doesn't accept. Online so
self
software doesn't
attestation is not done. reject. It's a hypothetical. I've seen the first ground.
Yes or not.
That is also genuineness of the document is not.
No,
That is not
it's
question.
not
That is
doubtful.
not in question.
It's not question. What to do, sir? That's
I
not
have
what-
given two representations, let them consider it.
Where is your representation?
Sir, annexure 7 series and 8 series.
Brother wanted to give some
Well,
fresh air to this. Yes. Representation.
Item number 22.
E2, my lord.
Item number 23.
For the listener.
In person.
In person.
My lord, check.
In person. But
There is the order of 22nd of.
your lordship will find that as base.
Oh, my brother was a party to it.
Page 7. Yes, my lord. My lord Justice Raman was the party to that. Your lordship will find the last portion of the order. Your lordship may kindly see para 7 available at page 8. From the relief sought in the petition, it appears that the petitioner sought for direction from this court to direct PIO to supply information as per the observation made by court by Dr. Such relief was not required.
But what's the content? Then there is no direction.
That's what I'm saying. There is no direction. Question of contempt doesn't lie.
Direction passed by you.
Only honorable
Give
court
us a chance to.
chance to file an appeal. That much only.
This was mentioned or it has come as
Specific action.
huh?
Yes, order is. On 15/5.
It came
On the
15/5 for the
order it
first
has
time.
come. Because if the content is matter between a court and the contempt.
Contempt.
So
These are
we
just
merely
an informant.
informant. Maybe somebody or give a notice. Well.
And that apart, my lord,
There are two ways, either we can drop the content proceeding there and on, there are two ways are things. Or we can give another chance by giving him a notice so that he will come in his hearings, we will know.
contempt being a matter between the honorable court and the
That's what I'm
contempt.
saying.
And that upon my lord, in terms of a lordship direction in this writ appeal, the appeal filed by the complainant has already been disposed of also.
What we do. Voting is paragraph 7.
That's a two is his appeal,
Yes, ma'am. It has been disposed of.
disposed of.
Yes, ma'am. That's what I received instruction. Right now it is single.
Not required because we are in a contempt jurisdiction.
Not
We
required.
will consider whether there has been any direction and that has been violated by you knowingly and
Yes,
willfully.
yes.
There is no direction to
There is no
you.
direction.
Yes, yes. I'm confident.
Pass it on. Since my brother is a party to it, so let him pass the order.
So what was direction in the reflection?
The read petition here since he has not enclosed and he has not described also in the petition.
Sorry, this prayer is compulsory.
Disposal. Yes.
It should be dropped,
Sorry. Drop it.
not disposal.
Right.
Contempt is either to be allowed or disposal is. Or the one matter which one?
Item 9, that's that last one.
My lord, I am for the vigilance, my lord.
You are for the opposite party.
Yes, my lord. So
Where is the petitioner?
The first hour he was there.
yes,
In the first hour he was there, you were at default.
yes, my lord. I'm
You-
sorry.
You were at default. Now they are in default.
Yes.
Neutralize.
So let it come on 10th of July so that I will file affidavit on the basis of the instruction I have received. And
You have already received.
yes, ma'am. Yes, ma'am.
No, it will simply adjourn.
Yes,
Yes, ma'am.
yes, ma'am. I will come.
Don't record it.
Yes, ma'am.
Obliged.
Mr. The other party. Yes.
Tenth of July.
10th July.
Please inform the other side.
Yes, ma'am.
Item 24.
My lords, unfortunately, the conducting counsel made an accident yesterday, and she has sustained a grievous injury in his leg.
3 weeks, let us recover.
So there is no interim order. Miss Sucheta Guman.
It's a bonus we do.
Right.
She is also in accommodation, my lord. My lord, it's good, it's good.
Right. Seventeenth July. Item 25.
What?
Cancellation of past.
Item number 26.
Lordship, item number 26, the cancellation of RC, but your lordship can kindly turn to page 15. The cancellation is of 2021, and the reason is the business, principal place of business not found available at the time of field visit. I have taken an inquiry, your lordship, after receipt of this copy, I have called for one inquiry report because this is 2021 and we are considering, no, not continued. Your lordship, just now I have called the officer because after receipt of the copy, I have called for one inquiry report. Whether the business has been continued or not, because he has not annexed any copy of the continuance of the business. So now I have called the inquiring officer, the authority, assessing officer, and he has said that the answer is in negative, and he is sending the report within 10 to 15 minutes, your lordship. So let it be adjourned to day after Monday. Your lordship, I will submit the report, inquiry report, because no business. For that reason, I have called for an inquiry report that whether
If they file the return and showing that this is what the transaction which they have entered. You, at the time of your inspection, there will not be a business activity.
today, your lordship, today inquiry has been conducted.
Come on Monday then.
Let me submit the inquiry.
Yes, Monday.
Item 27.
Your lordship.
28.
Cancellation.
Thank you.
Item 29.
Cancellation of RP.
Item 30.
Item 30 is the non-constitution of public tribunals.
Take this at the departmental level. How many cases are planning? And she has wrong also.
The non-constitutional.
No, this confusion of RC. What are you gaining?
Actually,
You should take it.
Actually,
Government level.
your lordship is well aware about section 30 and rule 23. There is a limitation.
Without amnesty.
Your lordship, only condonation, only for condonation of there.
For certain penalties, for certain things, that get it done. So after all, when you say that the business has to be done, then why you stop the business?
And from the beginning, your lordship, I have considered that your lordship may condone the deal.
That's why I'm saying that what is the difficulty?
Every day we receive 26 cases, honestly, we are spoiling our time.
Even under a direct tax, if you have not submitted your ITR within a particular time, you can submit it with the penalty.
It is
So
only,
they'll do it so that at least the revenue
it
is
is only
the interest of the
CBS
revenue is
can,
protected.
because it is central legislation and state.
Whatever.
Your lordship.
You take your. Anybody restrains you from taking any policy decision?
No.
Of your own.
No, your.
Is it required that central also come in tandem with you with respect to this particular aspect? It is your state who is to get the revenue from the defaulting persons.
Your lordship, I
Who have already entered into transactions.
Yeah.
Transactions are over.
What is the motto of the central government? Ease of business.
Your lordship. Collect the revenue.
Putting a
Because
Ease of business.
one thing I have also said to the department, that if you will continue in cancelling, automatically they will do the business. Even in cancellation, in non-registered, they will do their business. They cannot stop the business. A businessman cannot stop. So only government will lose the revenue. This is the thing.
Yes, for the next.
So notwithstanding.
Item 31.
Amendment, we are.
In absence of the GST filing. 32, yes.
Taking it pending.
32 is also similar.
33,
33 also similar, the absence of the.
31,
31.
31, 32, 33, all
all the
three are
same.
same.
Yes.
34 is the sequence.
Item 34.
Cancellation.
Item number 35.
Thanks.
Item 36.
36, that is cancellation, slightly change in the order. Because here, the revocation has been rejected. He has filed revocation within due days, and along with revocation, he has not annexed the return copies 3P. So for that reason, he has not replied. So revocation has been rejected. So the revocation may be restored, and let him file the returns, and my lord, Honorable Justice Raman can.
Yes.
The annexure 3 is the so-called for cancellation for rejection of revocation, and annexure 1 is the rejection of revocation. So only the order is to be changed. The so-called is that page 11, that any supporting document, you are required to file the pending GSTR 3B since March 2024 to October, upload GSTR 3B. And he has not filed any reply and not filing any return. So that
For the
my limited. Yes.
Item number 37.
Very. उसके दूसरी ओरिजिनल देव के दास ने महाराज
Right. Then 38.
Neither
this is here the issue is that the appellants were initially appointed. This matter was before your lordship on 15/5/2025, and your lordship kindly see the order.
Yes, I have seen the junior who is for the other side. Where is Miss Aishwarya Das? Is there any special officers that many are not appearing or have attended the court?
My lord,
Your adversary is not here.
my lord,
Your adversary is not here.
ma- will your lordship kindly fix a date? It is the government, my lord.
Yes, yes, but they are not appearing, sir. That is the whole difficulty.
I-
Where is Miss Das?
Your lordship, I had seen. Kindly pass.
Now she has.
Assigned to substance, sir, actually. Item number 38. Assigned to substance, sir. If I may call him also. The item number 38 is assigned to substance, sir. I
Could
don't.
not hear you.
Item number 38 is assigned to suspect, sir.
Shashwat Das. Shashwat.
Yes, sir. I just call him with your lordship permits me.
No, my lord, passed over.
Passover, my lord.
Next week, your lordship may fix.
He is on a virtual mode. We can't remain there.
Passover, my lords.
Passover means for
I'll just call him, my lords. This rat game running.
asking for an explanation.
No, my lord, then it may be next week, my lord.
When, sir?
Next week, your lordship may kindly fix.
Right. Fix the next week.
Miss Soma is it? Okay.
Your lordship, advocate P.
What is the possible date?
Your lordship, 26th.
26th June.
Don't put it on 26.
Oh,
Sorry.
next week.
3rd July.
3rd July. Will it be fine on 3rd July?
Your lordship, any other date? 3rd July, senior is inconvenient.
Thereafter 7th July.
7th July?
Grateful, your lordship, 7 July.
7th.
Yes.
Item number 39.
Yes.
Item number 40.
I'm filing a memo for withdrawal.
Item number?
40. 40.
There is no interim order?
No.
Item 41.
Oh. But one is the matter of public situation.
40 से बढ़ेगा 40.
They have been filed for intervention.
What is this?
It's a case of a
Correction, modification and review of the order dated 2nd of April 2024 pass in connection with OLR sealing case number such and such.
in this case, the OLR sealing proceeding in 974 months.
Can the High Court act as a review court of the authority?
My responsibility in base 10. Para 4.4. This honorable court directed to the.
Sir, I understand, sir. I am asking you the prayer which you have made. Either you say that to set aside this order, I can understand. But corrections, modifications and review. Can Article 226 be extended to that extent? Show us the law. No difficulties, sir.
Well, amend the prayer, man. According to amend the prayer, man.
It has to either you challenge this order to be such and such.
Provision challenge this order under Odisha Land Reforms Act, my lord, sir. Under Odisha Land Reforms Act.
Madam,
Is there any exclusion clause?
Yes, my lord, section 44, which talks about final settlement of this.
I am asking you, exclusion provision is there.
Yes, my lord.
What?
If I may read section 44, my lord. On the termination of proceedings under section 43, the revenue officers shall be.
That's the right of appeal.
Right of appeal.
I am asking an exclusion clause. Exclusion clause means there is a specific section which says that no civil court shall entertain any kind of situations or the proceedings. Is there any?
That is 37. 37 bola.
yes, sir.
Where is that?
Odisha Land Reforms.
Power of jurisdiction of civil court is there in section 67, my lord.
Probably you are not getting.
I understood, my lord.
What? Then why you are not answering? The straight question. What, section 37? No?
67.
Of the Odisha Land Reforms Act?
Yes, ma'am.
30?
That is 67.
67, sorry. So if there is a bar, can you? If there is an express bar, can you?
I am a published person, my lord. My demand is that, my lord, in the Honorable High Court in order dated 11/9/2023 to page 7, my lord, page 7.
37
Of my decision, my lord, I forget the order.
Let him amend the prayer because the prayer is very, very defective. The prayer is defective.
That is, actually, that is the provision of review, my lord. That's why I amend the prayer, my lord. And already, this already in the element already directed to the course.
We never need to amend the prayer.
To enable him to amend the request.
Amend it.
Yes, ma'am.
Yes.
Right. Item 42.
Yes.
42, there's a delay of 131 days.
Have you served the copy? Notice on a delay.
Item 43.
Item 43, I am appearing for the KV to Your Lordship for the respondent. Your Lordship, they have not served the appeal memo on us, Your Lordship.
Have they served you a condonation application?
No, Your Lordship, no appeal memo, neither the condemnation IA.
You are appearing for whom?
I am for the caveators, Your Lordship.
Aviator means,
Your Lordship,
what is the name?
Utkal Sine Chambers of Commerce, Your Lordship.
Yes.
Utkal Sine Chambers of Commerce.
Today, subject to direction, I will serve copies on them.
You have to serve the copy. What are you, why direction? But then what for the caveat provision is incorporated? It is your duty to serve him a copy beforehand.
I saw.
Serve him a copy
Grateful, Your Lordship.
after a week.
Right. Item 44.
Petition for condemnation of delay.
How many days?
400 days. Well, that's for some time may be granted to file objection.
Yes, file objection. 3 weeks,
3 weeks.
returnable after 4 weeks.
Objection to Rani, so for funding.
Yes.
Item 45, Your Lordship, for the petitioner. Lordship,
It's already over. Which pass over?
Item 37.
Pass.
Item 37. sir.
This is against the order of the Honorable Single Judge. The Lordship would see the interim judgment to the annexure of price, page 24. We have the appellant members is Paradip Port Trust. I just quickly show the relevant paras, page 24. Lordship will see from page 25, the facts have been narrated. Serial number 1, 2, 3, 4, 5. It's regarding giving appointment to an employee. If I can place those paras. The petitioner applied for the post of attendant under the advertisement dated so and so for visually handicapped category reserved for scheduled caste candidates. In his application, the petitioner submitted an old first aid certificate from an examination held on 21/10/2007. Pursuant to the advertisement, the letter dated 2016 was issued to the petitioner for document verification. Consequently, the verification process took place on 16/4/2016. During verification, it was found that the first aid certificate submitted by the petitioner had become invalid as it had not been renewed within the mandatory 3-year period. The non-renewal rendered the petitioner ineligible for the post. This ineligibility was duly communicated to the petitioner through a letter dated 13/5/16. The petitioner was granted a period of 15 days from the date of letter to submit a renewed first aid certificate. On 21/5/16, the petitioner submitted the renewed first aid certificate. Following this submission, the matter was placed before the screening committee for review. The screening committee, upon examining the renewed certificate, observed that it had been obtained after the date of advertisement. This language.
Then why the 15 days was given to him to submit? If it was after, then why 15 days was given?
They initially found that the certificate was not valid.
Understand. Then you said that you please submit the renewed the certificate within 15 days. Means you extended the time.
No. Your Lordship may see.
Roman 3, you just read the petitioner was granted a period of 15 days from the date of the letter to submit the renewed. And if this renewed first aid certificate is submitted within 15 days, then in that event, what is the difficulty?
Now, that step, my lords, that is something which is haunting the applicant. In fact, that step should not have been taken. So the question now is that whether that correspondence would bind the employer and the screening committee.
Who had made that correspondence, this granting 15 days time?
The secretary of Paradip.
So
Employer.
Secretary of the employer. So now the question is, my lord may kindly see the screening committee after examining the renewed certificate observed that it had been obtained.
No, I understand, sir. The point is, no doubt that all the requisite documents which are required to be submitted must be submitted on the last date or on the last date of the submission of the applications. Anything which is filed subsequent thereto will not cure it. I understand. But once the employer has relaxed the conditions and permitted him to file the renewed certificate within a particular time frame, and if that certificate is filed within the time frame, can he fall back and say, no, it is beyond the time? Then it is a farcical approach. This granting of 15 days time is a farcical one.
May I submit that? The question is that we found that there was a shortfall in his application. We wanted him to rectify that. Now the question is, he has come up with a certificate which is after the last date of advertisement.
Sir, your correspondence was also of a 13/5 after the last date of submission.
My lord.
And then by that letter, you granted him 15 days time. Then,
Letter has been extracted at page 28. Your lordship may just see.
so I am just looking at clause 3. The ineligibility was duly communicated to the petitioner through a letter dated 13/5/2016. That the petitioner was granted a period of 15 days from the date of the letter, so that is 13/5, to submit a renewed first aid certificate.
Now, my
Next,
lord,
on 21st means within 15 days.
I bow down to what falls. So, my lordship,
So-
lordship may just see what the letter says.
Yes,
That is at page annexure 2, page 17.
yes, page,
Page 17, annexure 2.
yes.
I'm just placing that with reference to the advertisement dated so and so.
So if you do not produce the same within 15 days, your candidature will not be considered. That means you have really given a fresh lease of life.
No, we have, but unless we
So-
kindly just see the language used. It is noticed that you have not produced the renewal updated, the English maybe I don't know.
Sir,
Renewal updated.
the proper method or the proper steps or a decision should be that once you found that it is not in conformity with your requirement, eligibility criteria, there was no occasion to give a fresh lease of life. You should have rejected the application. The moment you give and extended the time, can you now take a rebound and say, no, it was beyond the period, last date of submission? Why you gave it?
And there's one recent judgment of the Supreme Court where a similar fact.
No, there are line of judgments which says that if something is required to be submitted along with the applications, and on the last date of an application, if it is not, then subsequently it cannot be cured. I am conscious, but I am concerned, stuck up with this letter.
In fact, that letter has been the problem. So if I can say, Malad, that letter was a mistake. They wanted to backtrack. Now
Have you withdrawn
No.
subsequently?
No.
Then
The only thing is that whether that letter, whether there was a possible court
the only point is whether the secretary of the trust was competent to issue this. Who has taken a decision to make a publication inviting an application for filling up the post? Who was the authority to take a decision? Is the secretary?
Secretary, Manoj, is a high ranking officer. So that there I won't manage. I'm
And
just
the screening committee is constituted by whom? By the secretary?
now, Manoj, may kindly see there are other clauses in the advertisement which say that your application, if you have
Will be liable to be rejected if it is not in conformity. Every recruitment notice contain that.
Only thing is this letter. This letter, whether it
That is
can
what is there.
bring us to this manner. Now, if your lordship see some of the analogies given by the honorable single judge,
Applications which are incomplete received later without enclosure will be summarily rejected.
Correct.
There was
It
enclosure,
did not involve.
and you considered it, you found it not defective, it is.
the only thing that is coming to haunt us is this letter.
And this advertisement is made under the aegis of the secretary. And it's the secretary who has granted
It's
you a
not
time.
that a low ranking that's not.
No,
my-
himself, the same authority.
So, Manoj, only thing is that
The
if I
secretary
can,
was.
and if I can say that, Manoj, the language of that letter is that you have not produced the renewed, updated first ones. And then, Manoj, he says, you are advised to produce the same immediately from the date of issue of for taking necessary action in the matter. So, whether this would
And last paragraph, if
if don't produce, your candidature will not be considered. So, there were two.
what is
things.
the meaning?
Now, what he has done, he has brought out a new certificate after the cutoff date. The certificate is not within the last date of advertisement. There is one judgment of the Honorable
Sir,
Supreme
I
Court.
understand. I am not saying that there is not. There are judgments.
Hello.
But this is a special fact that has come up.
No,
if the authority, the employee himself, if the authority himself has extended the time, then in that event, what will happen? Suppose, let us go with the hypothetical case. They have given the last date of submission of an application is say X. Subsequently, the same authority has extended the last date of an application, say for another 1 month. Would you say, if the application comes within that extended time, that no, it was the last date, cannot be? Secondly, the officers lower in the hierarchy in the department, can he overturn the order of the higher officer?
I completely bow down to what falls from your lordship. Here, the issue is this: it's an individual. It's not a general extension for all.
I can understand, sir, if any other candidate who has offered his candidature within that, if he comes forward and challenges that you cannot unilaterally extend, I can appreciate it. But you being the mischief monger, can you?
Can I just show one judgment?
You are a mischief monger. You have created.
I bow down to what falls from your lordship. One judgment of the Honorable Supreme Court where they have tried to reconcile divergent opinions of the Honorable Supreme Court. Recent judgment, if your lordships, I can show. It is 2025 SCC Online SC 757.
Yes.
The first paragraph records that there were split verdicts. First paragraph itself. Present set of appeals have been traveled to this 3 judges as a result of split verdict delivered on so and so. Then, my lords, important would be paragraph 2.1 on the next page. The fact situation would be important. The Rajasthan High Court, so and so, published an advertisement dated 22/7/2021, inviting applications for appointment to the post of civil judge so and so, as per rules, which was admittedly silent on the aspect of last date of issuance of the concerned certificates for each reserve category. The last date for receipt of the applications was 31/8/2020. Preliminary test was held on so and so, followed by conduct of mains so and so. So this date is important, 31/8/2021. Now, thereafter, your lordship may skip the other portions and come straight away to paragraph 26, which would be page 10 of that reported. (26) and 27. (27) records what fell from my lord the Honorable Chief Justice, that it has to be the last date. And then if you also can see paragraph 32 onwards. Paragraph 32 may be important in the context of this case. In paragraph 36, there's a specific so and so that no relaxation can be granted. And the table at para 37 would be important in the context of that last date. All these applicants had got renewed certificates. But on the last date, they didn't have. If your lordship would allow me to show the table, there were certificates post that cutoff date.
Just one minute. I have a bad habit of reading the whole judgment.
I'm
then
so sorry.
just give me 2 minutes time.
I'm so sorry.
I'm a very fast reader, don't worry. Sir, yes.
No, my lord, let me see. This letter was issued.
No, you're citing a judgment. Now tell me what we want.
The relevant paragraphs from 32 onwards, the Honorable Supreme Court says that no relaxation can be granted after the last date of the advertisement.
Huh?
After the last date of the advertisement, there is no possibility of relaxation.
Is it?
Let me kindly see. Paragraph.
Sir, there you have to understand in two different ways. This relates to a Rajasthan Higher Judicial Service examinations conducted by the High Court. There is already a statutory rule in place. The statutory rule prescribes the modalities, how the examination is to be conducted and how recruitments are to be done. In that perspective, it was said that if the rules are silent, then you cannot assume the jurisdiction to go and bypass the rules and do whatever contrary thereto. That's why it was said that subsequently, when the advertisement was made, they did not indicate that what should be the cutoff date for the purpose of the certificate to be appended to the applications. Later on, the Rajasthan High Court issued a circular that the last date of an application should be regarded as a last date for submission for a valid certification. And if you do not, then there was also a clause that your application will not be considered, even if the admit card is issued to you inadvertently. That will not mean that you have been given a right or your right is conferred. The High Court can reject the application, may deny also the candidate to appear in the examination. Very interesting line, which I think I must brought to your notice, was paragraph 38 and the last 4 lines. The plea. So what it says that if there is a power to relax, if that is exercised, that discretion, then in that event that can be done.
Right.
If the relaxation or a discretion is not provided, then you cannot do it. In this case, there is no rules, statutory rules which governing the recruitments. It is all based upon the advertisement, putting certain conditions by a secretary. There is no fetter in the law that the secretary cannot relax or amend or issue a corrigendum. If the secretary has decided to extend, then in that event, where is the difficulty?
May I just...
This is what a line.
Why I showed this judgment, my lord, is...
You are correct. That's on a broad, normal, basic principles, what you are saying.
And what
no doubt.
Single judge has held.
I am again saying, there is no doubt. There are a decision of the Supreme Court as well. And since I came from a different court, so the full court decisions, full court decisions are also, special bench decisions are also there. Relaxation of an age In every public employment, you will find there is a cap of an age that the candidate between the age of 18 to 35 will be eligible to apply. The question arose that the candidate above the 35, whether they can be permitted to apply, say the age of 40. So relaxation that came, whether the relaxation of the age bar can be done by the authority. In that event, it was held that if the power to relax is conferred upon the authority, and if the authority exercises such power, then the entire notification or the advertisement cannot be impinged. Here, the secretary himself has issued this publication or invitations.
May I just show that document? Secretary, my lords, has issued an individual communication to.
No, this advertisement was also under
By
the
the
authority of the secretary.
But there is no general extension. Only to
If the secretary has put certain conditions, then the secretary can also amend the conditions.
No, my lord, he can. My lord may just see that letter. It's an individual letter saying that there is a shortfall, kindly make good. And thereafter, what the petitioner does, my lord may just see page 18 onwards. What the certificate, in fact, the document which he has given, that your lordship may just see, page 90. Just that document.
Then we'll have to go for a revised first aid certificate.
My lord.
And a fresh first aid certificate. You are trying to make a distinction.
No, but
that it is not a renewal or the revision of a certificate, it is a fresh certificate which he applied.
Fresh, and my lord may just see that document. Just, my lord, for a moment, just that document may be seen at page 19.
Yes.
He takes an examination at page 19.
Yes.
This is to certify that Keshav so and so has participated in so and so examination. The examination takes place on 4/5/2016. So that is way after the. So we write, then he he participates in that examination. That document would be important, my lord. Subject is first aid. The relevant examination report.
Page
19. This is what he gives after that letter.
No. Page 19 is the certificate of participation.
Yes. So after we tell him that you give your documents, there's a shortfall. This is what he gives.
What he gives?
He gives that he has participated in an examination on 4/5/16 and the examination report has been sent to the secretary of so and so, which will be issued to the candidate on receipt from national headquarters. That means after we write that there's a shortfall, he takes the exam and then wants to get it by whatever method. So then this is adding to the problems. We made a mistake by giving him an intimation that there's a shortfall. But then this is what he does. Now even if the question is, can we accept this?
Who is the petitioner here? The appellant?
The trust.
Trust. Through the trustees or how they have challenged?
My point which I'm trying to make.
Let us see. The chairman, the secretary himself is one of the party.
Secretary.
And he issued the notice.
He issued a notice
and
intimating
till date he has not withdrawn or remedied his mistake.
That's
the conduct of the party is also very relevant factor.
It is.
So if he is one of the appellant and till date he has not withdrawn that was issued by mistake, it cannot be done without an authority.
That letter we should have simply rejected it. Maybe out of thinking that he would be having the certificate or something. What went there, I don't know. But
the second thing is that
he has given
is a beneficial and a social piece of a legislation, the PD Act. And if the reservations in a public employment is also provided therein, one has to consider that. It's not a case. That was a case of the scheduled caste and scheduled tribe certificate, but it is a case where the physical disability is a criteria. and he is a visually impaired person.
That I'm trying to persuade His Lordship that once we go beyond the advertisement cutoff date,
But that is what is there. The plea of an appellant is sustainable and deserves to be rejected. Then the court says, no relaxation can be granted in a given facts of the case, nor can it be claimed as a matter of a right in absence of any such discretionary clause in the advertisement, rules, or instruction. If a discretion is vested into a secretary, if he exercises the discretion, where is it?
He exercised. For a moment, let us assume that he exercised and extended. After extending, did he give the certificate? The answer is page 19, where he says that I have taken that exam.
Have you taken this plea, or you have simply said the screening committee that since it was submitted beyond the last date of submission of an application? That's the only ground.
It is beyond.
This ground has not been taken, that it is a fresh certificate, not a revised certificate, that has not been taken. By your authority, screening committee. Screening committee, sir, it is there. Has he taken? He has not taken.
No, there, my lord, no.
Then I am reminding you of MS Gill's judgment of the Supreme Court. If your authority has not taken a particular ground or a point, can a counsel representing the authority at the bar take a different point?
That's the other thing, my lord.
So the judgment of the Supreme Court is staring at your face there.
It is, my lord. Page 30, the Honorable Single Judge holds that these are technicalities, and there's a 5 lakh cost.
Let us 5 lakh cost, I can understand.
There are two things. There's a 5 lakh cost on us for this.
We can take care of that.
I leave that to you, Lord. But this advertisement is something which
There was no.
valid certificates within that time frame, maybe we won't have any case. But the certificates that came about were after that last date of that.
Within the extended time.
That letter.
What is the meaning of the word extension?
I cannot improve on that letter.
So that is why
that letter is something.
If a time to file, that's why I gave you a hypothetical example. If the last date of submission of application is extended, if somebody obtained the certificate within the extended period, will you say that it is not valid?
Actually, you have come up with the second criteria for consideration.
Regarding reservation and manage the other.
No, second criteria.
Cost.
Manage, that's another point. Manage, these are.
Why didn't you file review then?
Review. That at least, Your Lordship, there are 2 points.
Yes.
Your Lordship, believe
You are the petitioner of the writ petition. What do you say?
My humble conviction is that in the advertisement, it was stated that if first a certificate from government recognized institution has to be produced. Whether a renewal or not, that part was not specifically mentioned in the advertisement. I produced a first aid certificate. They said that it is not it is an expired one. You submit a renewal.
How it is expired? Is there any rule which says that the validity would be for a particular period? Is there any rule?
That is their contention. That is
No, I am asking you, sir. Because in this judgment which is relying, there was a rule that the caste certificate, there was the notification that it will remain valid for a particular period. But is there any mandate that the certificate under the PD Act will be valid for a particular period?
As per my instruction,
There should be.
There is what my starting lawyer says is that the certificate is valid for 3 years.
There must be a statutory rule regarding that. Have you seen this judgment? If you read it, there is a rule which says, statutory rules, the certificate issued is valid for 3 years or 1 year. Here also we'll have to say that whether the certificate is valid one or not. If there is no time limit given for the certificate, if it does not expire by flux of time, can you take? Then the another question will, can the screening committee say that it is not valid? Show me that. Keeping this matter tomorrow first, show us. Validity of the certificate shows. Where is the rule?
Instead of tomorrow, can it be on Monday? Because Friday.
Friday is a good day.
We'll have to get it from.
That's the law we have to find out. Is there any rule?
Monday on top of
under the PD Act or something, because the certificate is issued under that Act.
For them to get it.
Physical Disability Act.
first aider certificate. It's a first aider certificate. It's
First aid.
First aid certificate I have seen. I just wanted to know because they say that it was issued in 2007 and therefore is not valid. You have to give a revalidated.
We'll get
Whether their stand was correct, because if there is any time limit given for such certificate under the statutory rules, then certainly they can. If there is nothing, then their stand for submission of the revised or a revalidated certificate is also wrong.
And moreover, that stands also contrary to the advertisement. The advertisement never stipulates that.
That is a different. Monday?
Monday.
Just give it a. Finish it up and then. Yes.
Item number 45.
Item 45, Lordships.
Who is appearing? Where is Mr. Siddheshwar Mahanti?
Yes.
45.
I'm here for the petitioner, Lordships.
Yes.
Lordships, this matter was dismissed and this matter was referred to Honorable Supreme Court by the Civil Appeal 5242 of 25. Your Lordships may be having at flag 10. So Lordships may I refer to para number 5 in the order?
So that was rejected on the ground that he applied for renewal, for substitution as a lessee after 3 years. So limitation period was extended. Supreme Court
Yes.
says that that cannot be a ground.
Your Lordship,
And remitted the matter for fresh hearing.
yes, Your Lordship. Yes, Your Lordship.
So what is a case made out by you? Where is the impugned letter dated 28/7/2016?
Your Lordship, if your Lordships are ready for hearing, can it be kept in July? So I will be fully prepared according. Your Lordship, I thought today it will be restored back and the matter will be kept for hearing.
The writ petition is already restored by an order of the Supreme Court. So there
Yes,
is
Your
no
Lordship.
question of re-restoration of it.
Lordship, may I take to the last para in para number 5? It says the parties represented today shall be bound to appear on the day for the purposes of fixing a date of hearing of the writ petitions.
Yes.
So Lordship,
anyhow,
may
when you want.
Lordship, any date after 20th of July.
Yes. Lago, our attention is drawn to an order dated April 16, 2025, passed by the Supreme Court in civil appeal number 5242 of 2025, whereby and whereunder the order dismissing the writ petition was set aside, and the case was remitted to the High Court to decide afresh on all the points taken by the respective parties. So the counsel for the petitioner prays for fixation of a date for hearing of the instant writ petition. So according to him, the matter may be fixed in the 3rd week of July 2025. So, the aforesaid prayer is not opposed by the counsel for the opposite parties. So let this matter be fixed on
17th July.
20th. He wanted after 20th.
24th.
24th.
Counter has not been filed in this matter, my lords. So
Yes.
counter.
In the meantime, it is open to the opposite party to file a counter affidavit.
Let's give me a copy of their.
And serve the copy well in advance. Yes.
Item 46.
Obliged, Your Lordship.
Last item is counter is not filed. Last item counter is not filed.
To online, I have filed already.
Yes, you have filed.
Already today. Today I have already filed to online. And
Sir, copy.
no, today I will send.
Copy.
Yes.
Mr. CGC submitted that he has already filed counter affidavit in the registry date.
Go out of time.
And also file the hard copy. You should file a hard copy. Right.
Today, during
File the hard.
He undertakes to serve a copy of the same on Mr. By tomorrow. List this matter. DSG anchor Mr. Mahapatra.
No, just now.
Serve copy on Wednesday. In court today. So undertakes to
There are two items. Second item, counter order finds this law. They are supposed to, if required, they will file the second item. There are appearing on.
You have already
filed.
Rajesh Kumar Mahapatra second item.
Second.
Senior planning council. Submitted that he was already filed content. Mr. Result of the bill. 6, 2 weeks application to file resign the document. List this matter. So first as a Let a second item the report.
If possible, उसमें की भी earlier date.
Second one is the DSJ application.
Item 47.
May I please, your lordship, my lord, item 47, my lord, kindly permitted to time, highly rejoined or mailed.
What? I will.
Resign.
Oh,
Rejoined or file, my lord. Permitted time.
Mr. Jayant Kumar Maji, praise for 2 weeks accommodation to file resign or pre-resign. Praise further कर दो अगर दिया है कि नहीं ना further list this matter.
10 July. Item 48.
A clear accommodation and after extension of 2 weeks time to file a counter. Last occasion, your lordship was directed to file counter. We pass the interim order. Let the interim order be continued with 2 weeks after. A detailed order has been passed in question of law is to be decided. Your lordship
I have to like that on the prayer of
So Mr.
time to file counter affidavit is extended by 3 weeks.
3 weeks.
3 weeks from date.
Then
Put the matter after 4 weeks. The interim order granted earlier shall continue till the next date.
Good.
Item 49.
Court and court and tribunal. That issue.
That
10-3.
49 to 10-3.
49 to court or
Again.
tribunal.
Your lordship.
Whether first appellate authority can be tribunal or not.
Lord, from 49, my lord. I beg my lord, I will file one amendment application in this. I will only 1 day time may be granted. I'm extremely sorry, my lord. I will file it. I'm in the process of already.
Mr. Abhijit Patman. That council seeks accommodation to file petition for amendment of the writ petition.
Yes, ma'am.
List this matter.
10 July. Item number 50.
This happened for the opinion number 4. Today I file my return of the body.
Huh?
I am appearing for the opinion number 4. I file my return of the body.
Brother has solved a copy today. My brother has solved a copy today. Also my current system. Both of them solved the copy today. I need 1 day time, subject to your lordship. 1 day time. Because I have filed only 1 day, so that I will. A friend has relaxed something. Sister has also.
At the request of Mr.
Your lordship has.
Tuesday or
That is the paving the way, my lord, that section 24.
No, understood.
1 day so that I can go through both the notes. Nothing more.
Yes.
at the request of Mr. Sujit.
Right.
List this matter. List this matter on. Indian Parliament.
26.
26
June.
26 is
That's
the
the
Thursday,
May not be convenient.
Tuesday and Wednesday.
26 may not be convenient to our 25th, my lord. It
That's why I say either 24 or 25.
Yes.
25.
25.
Oh, pleasure.
All that Passover
Matter.
50 is over, huh?
Yes. Item number 39, the pastoral matter.
Very small matter, lordship, but
Small matter.
very small.
Always very difficult because of my past experience. Small point becomes too big. Yes.
Very severe. In fact, it is a very small point, but because of the government is lordship, making it very complicated lordship. In fact, lordship it is lordship kind is very small point here lordship. Lordship, a work was work of the outage of 2019 lordship. The work put to outage in the year 2019, and I entered into agreement lordship in 2019 with a promise to complete the work within 2021. And Mr. Kindly see, the agreement has a particular clause. This is up to the employer. They can lordship alter the entire program. They can lordship guide the contractor to do that work in a particular manner on their own choice lordship. Actually, they change the entire plan lordship. That's why lordship, though it was after being completed by 2021, but they gave the approval plan in the 2022. So that's why there's a delayed period lordship caused because of their fault lordship. And as per the agreemental clause, it has in proportion to it has to be lordship extended the lordship. Without doing so, it has to be lordship come up with a fresh agreement. They did not do. And what they did lordship, they issued me so cause notice. And lordship, they went up for lordship for rescission of the contract. And lordship, to this extent, I approached before them, and I prayed before them, this grant me 6 months time, I can complete the work. And I approached this honorable court, and this one also directed to them to consumer representation. They did not consider and come up with a fresh advertisement. They did not grant me 6 months time lordship, but they come up with it, that advertisement, putting the time duration of lordship for 1 year, and lordship enhancing the entire tender lordship amount also lordship. And again, I approached before this honorable court. During pendency writ application, when the matter judgment was reserved lordship and judgment is yet to be pronounced, they did not disclose that we have not completed the entire tender process. But when the tenure of judgment reserved lordship, they awarded work my senior client lordship. And that was the subject matter now before lordship, and that has been stayed. And now lordship, by humble submission lordship, kindly say, why I have approached you lordship, kindly say. Lordship, kindly come to.
So if that writ petition where the judgment is reserved
Lordship.
Is delivered or not delivered?
No, lordship, this is the writ application lordship.
The judgment is reserved means?
Lordship after conclusion of concluding the argument lordship.
Before the preceding bench.
Lordship.
So let the preceding bench decide.
Lordship, and the lordship honorable, this is justice of the matter. And lordship that. When was it reserved? Lordship.
When was it by virtue of which order?
Lordship, that I have quoted that order lordship. At running page 14 of my brief lordship. 15 is the lordship order dated 28/24. 28/24 lordship. That is page 15.
1/5.
Lordship.
15 of your brief.
One brief lordship. 1/5 the brief.
The writ petition is page 1 to 21.
15 lordship, 1/5 lordship.
Yes, but your writ petition is of a 21 page.
Yes, lordship.
So you have quoted that order.
I have quoted that order.
Page 15.
Page 15 lordship.
So that was in relation to which writ petition?
Lordship, the present writ petition lordship.
This is a new writ petition. What?
New petition, last petition.
So that's why I am asking that with this order dated
6961.
6961 lordship. Page 12.
2024.
6961 lordship. Page 12 lordship.
Is it tagged to this? Yes, yes.
Lordship, that is complete.
It is tagged.
Okay. So it was reserved.
Right.
Then they issued the work order.
Lordship.
And thereafter you filed this writ
This is
petition
the-
challenging that particular action.
This resolution was given.
And what is the date of issuance of the work order?
Lordship, date of issuance work of Lordship.
The matter was already heard. Was there any interim order passed in that writ petition?
No, Lordship.
There was
There
no.
was no interim order. But at the relevant, they did not disclose that the entire process has been completed. They filed their counter, that's still pending, Lordship, that the counter is available there. They are not disclosing the tender process is either has been completed or.
Okay.
Date of Lordship, the 6/11.
Is there any force majeure clause in your agreement?
Lordship, that is there, Lordship.
Because time for completion that falls within that ambit of the
No.
pandemic.
Lordship. Just I want to, Lordship, can you come to page 92 for a moment, then. Page 92, Lordship, agreement. Lordship. This work has been completed, Lordship, can see 4/5/2021. Lordship,
What?
date of completion.
Where?
Lordship, can you come to page 99?
Come to page 11.
Yes, 4/5/2021. Yes.
Yes.
No, I got it. 4/5.
Then Lordship, can you come to Annex 3, page 99, Lordship. Stream 3/22, there internal communication, Lordship, this is. Annex 3.
Yes.
Lordship, it is addressed to Lordship by the, from the state government to the chief engineer, Lordship, buildings, Lordship.
Yes.
Only one paragraph. In inviting reference to letter number such and such, on the subject cited above, I am direct to say that after careful consideration, government have been pleased to approve the interim deviation statement as per the provision under para 6.3.17 of OPW Code Volume 1 amounting rupees 7 crore such and such amount, Lordship, with net excess of deviation of 2 crore 43 lakhs 31,163, being 46.73 excess over the corresponding agreement, value of rupees such and such, inclusive 12% GST, in respect of the work construction of HL Bridge over River Karani at first kilometer of Badaraula village to Ganeshwarpur Road under BSI in the district of Kendrapada, awarded in favor of Sri Birenchi Ganatsi, special contractor such and such, Lordship. So, Lordship, this deviation is approved after the completion of the tenure period. So, Lordship, this Lordship, they have not given this complete, Lordship, shape of the contract prior to completion of the contract, Lordship. That's why, Lordship, this tender condition protects me, Lordship. Lordship, can you come to clause 9, page 29, Lordship. Clause 10, page 29. Page 29, clause 10, Lordship, I'm ready. Lordship, got it? Clause 10. The engineer charge shall have power to make any alteration or on or addition to the original specification, drawings, designs, and instructions that may appear to him necessary and advisable during the progress of work, and the contractor shall be bound to carry out the work in accordance with any instruction which may be given to him in writing signed by the engineer in charge.
It should be the time for execution, completion of the work will be extended in the proportion.
Only, that is my only something for Lordship. So that proportion has to be given. That is the only grievance, Lordship. Yeah, Lordship, kindly see what? And Lordship, please see the tender notice. But Lordship, kindly see page 180 for a moment. Lordship, page very, Lordship, 180 and 181. These two pages are very important, Lordship. 180, 181, 81 and 182. I have given 3 photographs, Lordship, kindly see.
Correct.
Page 180, Lordship. 180, Lordship, kindly see. My entire, Lordship, kindly, I have collected the, Lordship, kindly see the space, and I have already constructed entire, I have created the structure also, Lordship. It could have been completed by granting me 2 or 3 months time, Lordship. Without, Lordship, joining issue with them, Lordship, I could have been completed the entire work within 2, that was my entire thought from the day one. They did not, Lordship, respect Lordship's direction. They made, and I make a statement, I can complete 3 months. 3 months, and they make a statement before this honorable court, no, we'll complete with it by 2 months. And Lordship can see their advertisement. In advertisement, they floated, giving them 12 months time, and Lordship enhancing the entire price also, Lordship. Plus.
Because I find that there was a division bench, earlier division bench.
Already.
Which really heard the matter and concluded it, and the judgment was reserved.
Sure.
Maybe that the Chief Justice has debited the office, but one of the judges is already available. Will it not be conducive that that judge who has really heard it, the matter, should also rehear the matter, because that will help. And if the decision is taken in that writ petition, it will definitely have some bearing in the instant writ petition. If that is allowed in your favor, then automatically this will go.
Grateful, Lordship. But it is Lordship,
But the difficulty is because she has already heard and she is available.
But I'm not standing for Lordship's view, but Lordship, if the government will take it, let's say small decision, entire issue will be Lordship.
Now the difficulty is they have already floated a new tender,
That's
they
true.
have already issued a work order.
So
we have to say that their action in haste
Lordship. Grateful, Lordship. Grateful. That is my
was not proper.
Lordship. That is only that was I'm expecting, Lordship. If that will do Lordship, then enter.
No. That is what, but the only thing is that if it is found that their action was in haste,
yes, Lordship.
then in that event,
Yes, Lordship.
so those have to be struck down, otherwise it will not. So will it not be proper that she should be a part of the
Lordship, after Lordship, that's it.
It was concluded in 2024 August, so not far off, one year.
Yes.
Decided.
Lordship.
But it was kept
For quite long time, Lordship.
for judgment.
But many matters have been Lordship released in the relevant time. We are also party in many writ applications.
Sister is
Sitting with the
available.
Lordship. Available with the Honorable Justice. Already. Justice.
Special bench.
In a break bench, Lordship, you can say with the Honorable Chief Justice.
That is what I am also thinking.
Lordship, Lordship.
Yes, that is what we are thinking.
Lordship.
I may be a part of it.
Lordship. Lordship. Lordship should be Lordship.
They are doing fixed and
No, Lordship. With the assignment.
yes, sir.
On the.
I will say this.
On to be heard first.
Yes, sir.
Yeah,
I will do this.
which has many orders also. I'm just
Yes, sir.
looking at.
And 3 REIT applications also he has filed one by one.
Many.
In 3 REIT applications, he has not challenged the decision order passed against him.
I will not.
Passed against him. And when decision order has become final, what right has got to come to run?
You can see that in course of the hearing, our attention is drawn to What is this page?
Lordship, page 15, Lordship.
Our attention is drawn to the order dated this August 20th 20th August 2024 passed in connection with the routine
Petition number
6961.
of 2024. Therefrom, it appears that the hearing was concluded and the judgment was reserved by a preceding bench comprising of the then Chief Justice and Savitri Rathore J. Since Savitri Rathore J is available, this bench feels that the matter should be assigned to a bench where she is she's one of the party there too. So let this matter be delisted and placed before the Chief Justice in the administrative side for passing an appropriate direction.
My lord, today, decidedly in 3 writ applications, whatever grounds, I have prepared a affidavit that I am filing today because it will be easier for him to overthrow it and
Just serve the copy on
Copy on it.
give it to me on that day.
I am sorry, copy on it.
Yes, conserve the energy and exhaust on that.
Yes, my lord, yes, sir.
Lordship, interim order continue. Interim order to continue.
Yes, interim order already
Fast.
operating is extended till the next day.
My lord, state has filed an IA for vacation of interim order. My lord, state has filed an IA for vacation of.
What?
State has filed an IA for vacation of the stay order.
Uh,
So, my lords, may I request for a early listing? my lords?
Because
I have been passing an order. If you want, I can pass that order. About that day.
my lord, I am sorry, the copy and
Since I have found both of them, I think the state must be standing by your side.
Yes,
No
sir.
difficult.
Lordship.
Yes.